All right. With that, I'd like to begin. So, good afternoon or good morning, everyone. I'd like to begin with some administrative matters today. To begin with, I'd like to clarify that both this panel and each of our panels throughout before and throughout the entirety of the JHS conference week will be posted on our YouTube channel, which will be linked in the chat below. Beyond this, the slides referred to by our presenters will be shared after the panel is over. So to begin with, I'd like to thank everyone for attending our JHS Week conference. It's my pleasure to welcome the panelists here today and to introduce our moderator, Tom Cardoso, a journalist for the Globe and Mail behind the publication Bias Behind Bars, which revealed institutional bias against Indigenous and Black federal offenders. With that, I'll turn the floor over to Tom and turn it over to him.
Thanks, Jerry. Hi, everyone. Thanks for coming. We're going to be talking about community corrections today. I wasn't able to attend some of the other sessions this week, but I hear they've been pretty interesting so far. So I'm not going to, belabor this. I'm just going to introduce our panelists, and then we can jump right into it. We have Renford Ferrier, a man that I've been talking to for years now over the phone. Sorry, difficult to hear. Can you guys hear me okay? Yes? Okay, great. So we have three panelists today. We have Renford Ferrier, who is he's serving a life sentence. He was sentenced in 1992 and has spent the majority of his life in prison at this point. He received a life 10 sentence in 1992 and proceeded to spend the next 30 plus years in prison, most of that maximum security. So you'll hear from Renford and his process of going into parole. He was just paroled just over a year ago now in December 2023. And we're also going to hear from Mary Campbell, who probably needs no introduction, the former Director General of Corrections Policy at Public Safety Canada, and just so involved in this space. And of course, we're also going to hear from Nikki Kish. Nikki is an Associate Executive Director at the Canadian Association of Elizabeth Fry Societies and a PhD candidate focusing on the sociology of law and punishment at the University of Victoria. Her community-engaged research focuses on Canadian life sentences, as well as historical and evolving contexts of institutions of law and punishment. Her professional and academic work focus on raising public awareness, mobilizing community, and advancing legislative and policy change to address and transform the harms of incarceration in Canada. So the way this is going to work is we're going to hear from Renford first, and then I'm not sure who's going to be second or third, but we'll figure that out. And then hopefully we'll have about 15 minutes for questions and kind of like a Q&A at the end, and then there'll be breakouts after that. So that'll take us through the next hour and a half. So without further ado, I think we can let Renford take it away. He's not able to attend today, so we're going to hear from him via video. I spoke with him yesterday, and so we're going to hear that now. Rhea, sorry, I think there's no sound on the audio, on the video.
Rhea, it still appears that there's no sound for this particular video. Perhaps we can have one of the other panelists go for now, and we can try to work out the sound issue. Thank you.
If that's the case, perhaps should we proceed with perhaps Mary? What do you think, or Nikki? Do you guys have a preference?
I'll let you decide, Mary. Always technical difficulties.
Okay. Let me turn my camera back on. Okay.
All right. Well, thanks everyone. I'm going to keep a close eye on the time, as is our host, Tom. What I want to talk about today is a relatively short list of reforms that I think are needed to the parole and conditional release system. It was easy to come up with a list because I did a long list in November of 2015 and gave it to the Trudeau government, and they nicely sat on it for a decade. So the issues are still timely now. So I've pulled out a few of them that I think are kind of major ones, or ones that are doable. So some of them require a statutory change, but some are just a matter of practice and policy. I'll start with the statutory ones. First one is repeal the Harper amendments that delayed conditional release reviews after the first denial. You may recall that normally if you've been denied, you are to be heard again within 2 years. And Harper said, no, that victimizes the victims further. And so for violent offenses, you'll have, in fact, 5 years to rehear the person's application. Well, do the math. You know how long sentences are, even in the federal system. It means that for a lot of people with so-called violent offenses, and some are violent, they'll only have one parole review, because then they'll run into stat release or warrant expiry. There's nothing to be gained by delaying the hearings. You know, we got to keep the system moving, keep the pressure on everyone. Just repeal those things, go back to what it was. Number two, an old issue as well. A number of us feel that CFC, the parole hearing, should be giving their assessment of the case, but should not be making a recommendation. You know, talk about what it would take for this person to be successful in the community and why. You've identified those things. Talk about the basis for them. Talk about then whether they exist for that person. If they need a stable residence, does George have a stable residence? But don't go into making an actual recommendation. That's the board's job, is to make the decision. And why there's so much fuss about a great concordance rate is beyond me, between CSC and the parole board. So just stop it. Number three, slightly controversial, abolish return to penitentiary for simply a breach of conditions. Now, I appreciate that sometimes a very serious breach of conditions can be a red flag, but I think it's incumbent on the board, the department, CSC, have a look at the American experience where they've gone to this, no return for breach of conditions. Have a look at other countries that have done that, see what makes it work, what makes it not work. But should someone be going back to penitentiary not having committed a new crime, you know, strictly a breach of a condition? So I think that one bears a little bit of scrutiny, but should be pursued. Number four, oh my God, don't get me started. Abolish the standard conditions of parole. Look, they're illegal. CCRA says every decision has to be the least restrictive that promotes public safety. Least restrictive option consistent with public safety. Those standard conditions, I did a history of them. They date from 1960. They were written by a bunch of, sorry people, but old white men in 1960, reflecting their values and what they thought it meant to be a law-abiding citizen. Truly, they go back to 1960, which is 65 years ago, almost as old as me. You know, the standard conditions, all conditions should be special conditions. All conditions should be imposed on a case-by-case basis. That's what the law says, and that's what you should be doing. At the time you're imposing those conditions, please state the duration of them. They're not forever, or maybe they will be, and state when they should be reviewed. This is particularly so for long sentences or lifers. You know, you should be looking at those conditions every 2, 3, 5 years, whatever. Are they still needed? In conjunction with abolishing the standard conditions is, we used to have a thing called parole reduced or discharge from parole. Would you have people who have been successful in the community for 5 years or more? The research tells us they are no more of a risk than you or me or your next door neighbor. Unfortunately, right now, there's a CSC policy about reporting, for example, and the parole board allows this to happen. Even the best person in the community right now has to report quarterly, all right? Why? Why? That is not in compliance with the principles of the CCRA at all. So knock it off. If the person is low risk or is, less of a risk than I am, their condition should really be minimal. Maybe report in once a year, and you will save some money. You'll probably annoy some parole officers who like to have good people on their caseload. But really, this is ridiculous. The people I know who are reporting quarterly, I should be reporting quarterly, frankly. Number 5, again, maybe a little controversial. I think that the law should state that all parole board members should have a university or college degree or equivalent criminological experience. I think all executive committee members should have an adequate level of knowledge of administrative law. They should have a fairly high level of management experience as well. I think ongoing training needs to be prioritized. Perhaps it is. Be nice if you could tell us a little bit more about the training that is done. And I think all board members should have an annual feedback session with their regional vice chair. Now, I know from your documents that you say that they do have some kind of review session once a year. I hope that's happening. I guess I could ask the former Ontario vice chair if that was happening consistently. But I think that there has to be a certain level of standard of professionalism that is incorporated in with the other factors, along with the diversity factors that are so important. That's number 5. Number 6 with the administrative changes. Please divorce your appeal division from the executive committee. If you're a true appeal division, you should not be voting on policy matters, for example. There was a case a few years ago where the person was denied a type of release and appealed, and the appeal board member said, well, I voted in favor of that policy at our meeting, so I really can't go against it now, so I'm upholding the denial. That's not an appeal division, okay? I would also ask that the law be amended to say that all appeal division decisions should be posted online. I'm a big fan of the Veterans Review and Appeal Board, VRAB. They post all of their appeal decisions online. They take out any privacy references, obviously, but they're there. They're on the Canada Legal Information website. Board members should be required to read all the appeal division decisions. Board members should be encouraged to read each other's decisions. I was told that apparently they're discouraged from reading each other's decisions. Well, how are you going to learn if you're not reading what each other is writing? And if there are decisions marked by the chair, vice chair is particularly important, they should be required to read those. Those are 6 legislative ones. Let me just briefly look at 4 where I don't think a legislative change is needed. Number 1, there should be a legal services unit in every PBC regional office. Believe me, I've read some decisions that would have benefited from a quick review by legal services before they were delivered. I wonder too, why are you clinging to making the decision on the spot at the end of the hearing? Have you ever thought about that? I know nobody wants to know what is going to happen, but why do you do it on the spot? You could switch to, a commitment within 5 days, say, to release a decision. That would give you a chance, if you're a board of 2 or 3 people, to talk to each other. And it would give you a chance to get any legal advice from your legal services unit that you think might be useful. Again, just you do it at the end of the hearing because that's what you've always done. Well, think about whether there's a better way. Second, the PBC policy manual. I have looked at the new one. It's a vast improvement over the previous one, so thank you for that. I would like to see actually an annotated CCRA. Your manual starts with cross references to section numbers and then goes into a narrative. I would actually like to start with the actual law. I know I'm biased. Start with the actual law and then annotate that. And again, you should look at the Veterans Review and Appeal Board. They're starting to write an annotated act for their members' use. Also, your policy manual doesn't seem to reference court cases, and you have court cases, you have decisions. So it'd be nice to see those referred to as well. Number 3, you're getting a copy of this list afterwards, by the way. Have a look at it and implement the American system of rewards for good behavior on conditional release. You know, the carrot is mightier than the stick. I know some jurisdictions in the US do it, and probably other countries as well. So have a look at what more you could be doing there, because the person who behaves perfectly seems to be treated about the same as the person who is not behaving perfectly. Number 4, and it's the last one, please communicate. I'm begging you to communicate. Proactively, consistently, in a targeted way. Don't preach to the converted, and don't communicate, obviously, after a sensational incident. Innovate a little. Like, you've got a lot of information on the Parole Board website. A lot of it is not very accessible. I don't think my next door neighbors in Peterborough could find what they were looking for. Try something creative. Put a little quiz on the website, you know, 5 questions, interactive. People can see what they know or don't know. Have a chairperson's letter once a month. Try to package the information. You've got a professional audience, and we are desperate for facts and figures, but you've got the public audience as well. And it just has to be constant and written in a way, obviously, that's accessible to the average person. Put some outrageous statement on the website and then indicate if it's true or not. Stimulate people. I hope you're not using TikTok, because I never go on TikTok. So if you are, forget about it. But make much better use of your website in a non-bureaucratic way. And if you can, translate from bureaucraties to English or French would be super. Those very quickly are 10 suggestions to improve the system. All of them are doable. All of them have pretty much been kicking around for quite a while. So let's hope. And Nikki can tell us if they will solve some problems she's encountered. Thanks.
Thank you, Mary. Oh, sorry. Yeah, I'll jump in. It's emotional for me to follow you, Mary. I've never met you before, but I've spent half of my life advocating for the least restrictive measures principle to be understood and applied. And despite it being a beautiful legislative tool, it's a tough sell, unfortunately, in practice. So I continue to have my life's work shaped by some of your work, and I'm very excited that I've been brought into this conversation today to speak about one subsect of people who experience parole in Canada, life sentence people, who Mary recognized as being particularly important to consider. And a lot of my recommendations and the findings of my research actually follow a lot of what you shared, Mary. So I've prepared a PowerPoint, but given that this presentation is being recorded, I think it's better just to speak directly to the audience. So if you see me reading with my eyes, it's because I'm navigating in the PowerPoint in the background. But as Tom mentioned, my name is Nikki Kish. Oh, and if you could just keep me on time, Tom, I'm looking at my PowerPoint and not the clock. And I also can't see the chat, just to keep that in mind. But yeah, my name is Nikki Kish. I'm the Associate Executive Director with the Canadian Association of Elizabeth Fry Societies. I'm also lucky to be a PhD candidate at the University of Victoria. My graduate research focuses on many aspects of life sentences and institutions of law and punishment in Canada. My master's research, which I just completed, focused on people who experience parole for the lifetime. And so I'll take you through a bit of the scope of my research, the context, who I talked to, what I found, and then similar to Mary, what both my participants and I think needs to happen. I can see from the audience that a lot of you are very, very versed in what I'm about to be talking about, but again, because this is recorded, I'm going to be speaking as if folks had no idea. So Thank you for joining me in this presentation, and here we go. So for my master's thesis, I spoke to 19 individuals with life sentences living in the community on parole in Canada. I used a socio-legal framework, and that means I study how the law impacts people. One thing to note about the composition of my participants is that these are people who have been on parole for a very long time. I was super lucky to have my recruitment poster shared broadly. So I had almost 70 people contact me interested in participating in my study, which is really remarkable, quite unheard of, and I think speaks to the need for life sentence people to have a voice. Over 57% of my participants have been on parole for over 10 years, and over 42% of them have been on parole for over 20 years. 5 of my participants had been on parole for 30 or more years. So these are people who have been living in the community, been working their hardest to be fully participating in society for a really long time. So a bit about the life sentence in Canada as a backdrop. Life sentences formally replaced the death penalty in the Criminal Code in 1976. That means that it's been almost 50 years. It will be the 50-year anniversary, if you could call it that, of the life sentence next year. Life is a mandatory minimum sentence for both first and second-degree murder convictions. And people who are sentenced to life are also given a parole ineligibility period, meaning that if somebody is sentenced to life, they have to go to prison for not less than and not more than 25 years before they become eligible to apply for parole. And as most of you here know, that is no bearing on whether or not people will and do actually gain parole. Now, for people given a life sentence, all the participants in my study, they're convicted of something. The scope of convictions that can result in life sentences in Canada is much broader than first and second degree murder. But the bulk of people sentenced to life, almost 80% are sentenced as a result of a second degree murder conviction. So all of these people enter prison knowing that they won't even be able to apply for parole for a decade or decades. And the Correctional Service of Canada in penitentiary environment then absorbs people into an environment where there's an expectation that parole is the goal, that even though this is years and decades away, you're working toward release. It is the carrot, the freedom, that which you have to achieve, lest you die in prison. And this goal becomes particularly it's challenging for everyone, but it becomes particularly challenging when we start to understand who goes to prison with life sentences, the composition of who these people are. So a little bit more background information. Approximately 39% of people sentenced to life in Canada are living in the community on parole. Parole is the highest degree of liberty that a life sentenced person can ever attain, and parole conditions last until death. Presently, quite a considerable scope of Canada's federally sentenced population have life and indeterminate sentences, approximately 27%. So we're talking about a big group of federally sentenced people. A scholar who I speak of fondly and frequently, Deborah Parks, her research illustrates how life sentenced people have been spending longer in prison from the time that the sentence was introduced in the criminal code until now. And that's both because judges are imposing longer parole ineligibility periods and because people are spending longer in penitentiaries prior to gaining parole. And as the findings of my study demonstrate, parole conditions are not being gradually reduced over time. People are being kept under a sort of perpetual punishment, as I characterize life parole. So the last context, a lack of data excludes Canada from global scholarship understanding life sentences. There's 2 amazing scholars, Christina Appleton and Dirk Vandersmit, and they've compiled what is known globally about the life sentence. And it's striking that Canada has not been able to be included in this data because our government simply hasn't studied it. Frank Poperino did the last study in 1991 that looked into whether or not long and life sentences create an adverse impact by virtue of the sentence. There have been 2 qualitative studies that have looked at life sentence people on parole, the last dating to 2013. So for a number of reasons that I won't get into today, life sentences are really understudied. We simply haven't known what happens to people or what the efficacy of such a sentence is. And some demographic context into the participants in my study. Who did I interview? Well, I prioritized of all the people who reached out to me, people who had been on parole for longer. So I was really looking for people who had experienced more time on parole. But one of my participants hadn't been out for 2 years. And 3 of my participants had been out in the 3 to 5 year mark. So really a range of time on parole. The most striking finding in my study is that a lot of people are given life sentences as kids. And again, I would urge you to read Deborah Parks's research, who is trying to uncover the specific numbers into how many children and youth are given life sentences as adults in Canada. In my study, 5 participants of 19 were 17 or younger at the time of their arrest. 6 were 18 or younger. 13 were 21 or younger. 16 were 25 or younger. So only 3 were over 25. And as we know, in social science and across the sciences now, people's frontal cortexes aren't fully developed until they're arguably 24 or 25, and this can be differentially impacted across socio-demographic considerations and different groups of people. So a lot of young people in my study were given life sentences as kids. A lot of young Indigenous people were given life sentences as kids. So of my 19 participants, 4 were Indigenous women and 4 were Indigenous men. That's 8 of my participants were Indigenous and 2 were Black men. So a lot of young Indigenous and Black people were given life sentence, mostly for second-degree murder and mostly for an event of unanticipated violence that resulted from instances where they were intoxicated. And many described evidence in their cases of intersectional bias that they weren't aware of in their youth, which suggests and aligns with what other fields in the study of wrongful and overconvictions in Canada know, that there's a prevalence of wrongful and overconvictions at the murder level. And especially for young people, for everybody, getting through those decades in prison and even getting to the point of parole is a great challenge. But especially for young people, my participants described having very social priorities when they went into penitentiaries. So these are 17, 18, 19, 20-year-olds. They're kids, and they're thrown into a penitentiary environment, and they want to make friends and fit in. And this fundamentally misaligns with the expectations of the penitentiary, where institutional charges and everything that goes on a person's correctional record is then used forever in the case of a life sentence and really moves young people away from the goals of parole. But all of my participants did, of course, get to parole, and that's what we're here to talk about today. I just wanted to share that for the people who were able to get there, their journeys were long and complicated. They spent their formative years in prison, and this really shaped both their life courses, of course, and how they have been able to integrate into society and participate in society following incarceration. And that's the goal, right? That's the goal of this whole system, is to move people back into society and then encourage practices which allow full participation in society. And unfortunately, the people who I spoke to don't benefit from full participation in society. What I really found wonderful, everything about your presentation, Mary, but specifically was the call out of the administrative parole conditions, the standard conditions and the ways that they're being imposed by the Correctional Service of Canada. So my research found that the scope of parole for life is operating outside of the law by virtue of 2 conditions, especially. You could barely call one a condition. I'll get into them in a second. I'm just checking the time here, but there are 2 types of parole conditions: special conditions imposed by the Parole Board of Canada, and then standard conditions imposed upon everybody on parole in the regs. And one of the ways that people who are on life parole are really experiencing persistent exclusion from life, from relationships, from vocational and educational, from dream attainment, is through the practice of geographic restriction. So essentially everybody on parole, regardless of whether you have a life sentence or not, is kept in the same city, a small radius, and this radius is never broadened. In section 161.1 of the regs, this is located by saying that every person on parole will remain at all times in Canada within a territorial boundary fixed by the parole supervisor. There's nothing written in the law that this boundary must be so small, nor that it can't be broadened over time. However, in practice, all of my participants have been kept under very restrictive geographic boundaries for 10, 20, 30 years. These average to about 30 kilometers, just like a small radius. In more rural areas, they can be bigger, and in more urban areas, they can be smaller. but it's an area that people can't go without extensive permission processes, community assessments, and travel passes. So at least the travel radius is located in the regs, although the way that it's being administered, I would argue it is highly restrictive and, again, not aligned with the fundamental principles of the higher legislation and certainly misaligned with our Constitution. And so anytime a person on a life sentence with a life sentence on parole wants to leave their city, they have to ask their parole officer. And their parole officer then engages in a lengthy process, contacting the people that they want to go to, finding out the dates and times that they want to go to, in many cases completing community assessments with the people who they want to attend, issuing a paper version of a travel pass, telling the individual that if they don't keep that paper version on their person and if they aren't able to produce it at all times while they're outside of their boundary, that they're then in breach of their parole. And so this deters people from leaving their city. This in my research is really expressed as a form of intensive surveillance that people, one, don't want to go through after living on parole for 10, 15, 20 years, and don't want to subject their family members to. Community assessments are the other component of how people on parole for life are really being prevented from having relationships, from having jobs, from developing themselves for years and decades after parole. And a community assessment is imposed anytime a person wants to maintain a relationship or engage in a new relationship. Historically, these processes were a great pre-release tool. They were originally called community investigations, championed by early parole agents to show that people were redeemable. They would go into the prison, figure out what sort of supports people had in the community, and then put this forward to the event, what became the parole board. Community assessments are being used in perpetuity. Every 2 years, a new community assessment can be requested by a parole officer. So I have participants, especially Indigenous participants, who were released to communities far from where they're from, just by virtue of how the prison system involuntarily transfers people into communities where they don't know anybody. Their family live across the country. Then to apply to see their family, they have to go through the travel pass permits and this community assessment process, which has parole officers go into the homes of their family members, investigate their merit, investigate their worthiness, disclose all the correctional file information of the people on parole, and really impose themselves into the relationships of people, and not just pre-existing relationships, but new relationships. My participants wanted to date and make friends and were terrified. And I know I've gone over time and I spent way too long on context here, but just to anecdotally share, imagine that you wanted to meet somebody and you already have, even without the prison system, all of these things that impact the way that you interact with the world, and now you have to introduce anybody who you want to meet to your parole officer, and then the parole officer meets them independent of you and shares all this information about you and also inspects them. It's a very uncomfortable process. And when there are not special parole board conditions requiring the monitoring of regulations, when, as Mary said, when people have very, very low levels of risk, I can't find a legislative basis for the efficacy of these, but have found that they've been extremely harmful for people, especially over time, especially when people are just trying to move forward and build good lives for themselves. And so what we recommend is that, consistent with global standards, Canada implement off-ramp and sunset policies related to life sentences for the termination of parole. We want parole conditions to be proportionate to risk and to be able to be gradually reduced over time. This happens in most jurisdictions globally. It's really important for us to recognize here that we're one of the most punitive regimes globally. And I know that's hard to recognize, but really dig in, do the research here and see that if people have gone through years of prison, if they've been released and they're trying their best to participate in society, why are we allowing for two processes that don't have procedural safeguards or fairness attributed with them to isolate people as they have occurred here? I'll stop now. Thanks, Tom.
Thanks, Nikki. Lots to think about, and we'll dive into that soon. Hopefully we can hear from Renford. What do you think, Rhea?
I think so. Here we go.
So, Renford, maybe we could just begin. Can you tell the audience, the panel, a little bit about who you are and what your trajectory has been?
So, name is Renford Farrier. I'm a lifer on parole. In 1992, I was sentenced to a sentence of life 10 with the eligibility for parole after 10 years. And that exceeded that 10 years and went into 32 years. And I was recently paroled in 2023, December 1st.
32
And
years. So
yeah,
not 10 years as the judge had ordered, well, a minimum,
mhm.
but 32 years in prison. And my understanding is you spent a lot of that in maximum security. Is that correct?
Yes. But maybe I would say a good part of 25 years was spent in maximum.
Wow. And a lot of that also in solitary. All right.
Yeah, so over almost close to 8 years in total in solitary confinement.
Yeah, I think at one point you spent 18 months continuously in solitary.
Yeah,
right?
the longest time I think was 18 months straight
Yeah.
solitary confinement.
So
23 on 24.
this this panel is in part about reintegration, and
Mhm.
you have made a very huge change in the last few years in well, I mean, look at where you are now. So can you just tell
Mhm.
us a little bit about your transition from prison to community and how that happened and what your experience of that has been?
So my transition from prison to community wasn't just by myself. You know what I mean? I had tremendous support, because without that, it wouldn't have been so seemingly easy as it is. So the first support came basically from yourself, Tom, and Catherine, who made my people know who I was and what was happening. And in that entail, help bring more people to the table to offer their support. And that entailed help me to make this transition seemingly easy, because there wasn't the pressure of finding a work and having a place to live and who can I turn to and where can I go, right? So for myself, the work started, I want to say maybe 8 months prior to me being released.
And the process, I imagine most of the audience will be very familiar with it. You went to the parole board, not for the first time, but
Mhm.
that's neither here nor there, and made your case, and ultimately the parole board decided that you were a good candidate for day parole. Can you tell us a little bit about the adjustment period going from being at, I think it was Spring Hill Institution,
Mhm,
right,
mhm.
to then being at a community facility?
So once the parole was granted, um, to be honest with you, it was kind of surreal, because I was no longer going to be in a cell, and after being there for 3 decades, in a moment, you're like, is this really real? And when my family came to pick me up, and my attorney, I'm a helper and from Spring Hill, and I'd always said in my prison sentence that at the end of it, I would want to walk through a prison gate, because that's the way I entered. And to actually capture that moment was significant for me. And then arriving at the halfway house, my initial thoughts were just joy, because I was no longer inside of a fence. Right. And I didn't take it as anything other than that, because this, compared to where I was coming from, I was free now. I didn't see the halfway house as a restriction, as a hindrance, or as anything other than a positive step forward. Right. And again, with the support of all the people that were involved with me, I always had somebody I could talk to or communicate with and help me along with that transition.
Well, what about what about CSC? Because if you're the moment that you go to
Mhm.
prison, to federal prison, CSC is going to theoretically anyway put you through this battery of programming, of supports, all of which is designed to help the person who's now in prison to reintegrate, right? So did you feel like did you feel like the programming that you got from CSC before your parole prepared you for the reality of being on the outside?
So if I'm being 100% honest, like CSC's programming did nothing for me other than to check a box. Because if I'm being 100, CSC programming doesn't deal with what your life outside may look like after incarceration. The programs that CSC are delivering are trying to teach you how to better manage emotions and things of this nature while in prison. The focus isn't on what you will do when you get out, right? Because if they were doing programs focusing on that, they would be doing programs to help people with technology. There is no program based with technology. They would be helping guys to further their education. There is nothing to do that. Once you finished high school and go on to secondary post-education, you have to do correspondence, and very few universities are doing correspondence. So you're limited to the courses you can take, right? So for myself, CSC offered nothing other than a place to hold me. The process of educating myself and giving myself the tools that I needed to better assimilate society, that came from myself, my family, and the people that were supporting me.
And what about, you've already talked about this a little bit, but are there other types of programming, policy, changes in law even that you think would be helpful to people trying to follow the same path that you're walking down right now?
So like I'm kind of dating myself. I'm old enough to remember a time where the orgs were inside the institutions, and that was crucial. So there used to be a project called the Queen's Law Project that was run by the John Howard Society in Ontario, where they would have law students and criminology students from Queen's University come in and mentor guys, help guys learn how to write habeas corpuses, help teach guys how to write proper grievances, right? And start to prepare guys and help them to educate themselves on where they are. Those programs no longer exist. So, and I also believe John Howard had another program in place where prior to release, they had, I can't remember the title, but this individual would come to you and find out, do you have ID? All the things that you were missing, they would go about trying to find that for you, right? And it was crucial because one of the things that I found really kind of hard to navigate when I got here was getting ID. Because when you're away for a long time, you lose ID. And CSC does not have any program, anything in place that helps guys coming out facilitate ID.
When you say ID, you're talking about?
For myself, I'm in Nova Scotia, so you need a provincial Nova Scotia ID, a health card. I had my SIN card before I went in, but you need more, I think like 2 pieces of ID, 3 pieces of ID to get other ID, right? And when you get here, ID is not something you want to be worrying about because there's so many other things you need to worry about. And ID is a simple thing that can be achieved by filling out a paper.
Right. Well, I wonder, we have a couple of minutes left here, I think 3 or 4 minutes left. I wonder if you could, I think a big part of your journey and your experience has been not only, the long road that you had to take to get on the outside, but also the fact that you're a Black man, right?
Mm-hmm.
So I wonder if you can talk a little bit about how your race has kind of tinged or affected your mode of reintegration. Do you feel like, so to put that in a question form, what kind of supports have you found for, as a Black person trying to reintegrate after so long in prison? Have there been any supports of that sort that have been racially geared?
So, as in terms of supports based off of color, again, none of that happened from CSC, right? That took place from a group called Urban Res while I was in there, and also the Nova Scotia Brotherhood, which is also based for colored individuals coming back to society. And the org that I work for, John Howard Society, right? They made it a point to incorporate me in their org as a person of color, right? Because they wanted to highlight that this is what we're about, right? And it's been welcoming ever since. And the challenge that are faced men, women of color coming back into society from incarceration is different than people of non-color coming back into our incarceration, because there's no direct org that is set up for that. And there's countless orgs that are set up for individuals that are not Black. Right? There's good thing John Howard and EFRI, other organizations are incorporating that. But there's like the Nova Scotia Brotherhood, they have 902 Man Up, but these orgs are, it seems they're geared specifically, I don't want to speak ill of anyone, but basically for their region. So if you are not from that region, coming from another region, it's hard for you to get lined up with these orgs. Whereas I said, the JH, the John Howard Society, the Elizabeth Fry, they are not concerned with geographics. They're just concerned with assisting the best they can.
So I wonder, just to, in the like a final, if we get a final thought from you for the panel and for the audience, you know, if people were to take away one thing from what you're saying today on reintegration, on the long path that you took, on the experience of being Black in prison, and you know, trying to get out, if you had to leave people with one thought, what would it be?
Well, like I was just explaining to you the fact that, because I think we're a lot of people have the misconception that CSC is actually rehabilitating and helping individuals and giving them the proper programming. There is no program for Africa Central, none. There is no program in CSC for Black folks, right? For Indigenous, none of these things. You have to culturally get them, and it's important that we address the need of getting orgs back into the institutions, because the orgs are the ones that are creating the proper release plans and the supports and the resources that these offenders are going to need. Sorry for the word offenders. Individuals will need upon release, because once you have been released, just like while you were in there, CSC didn't cater to you, they will not cater to you once you are released either. So it is important that the orgs try to start to get back within these institutions to help these individuals, like I have, seemingly make the transition back to society easier. Because the process has to start not when the person gets here, right? Like I said, my process started maybe 8 months before I knew I was getting out, because it's a building of a relationship, building trust, building something that is going to be sustainable.
Well, that's great. I think that's it for time. Rhea, how are we doing on time? Well, with that, I think that concludes the panel segment, and I think we could jump into questions. I don't know if you have questions, perhaps you could raise your hand, and we can unmute you, or you can unmute yourself, or alternatively, you can put a question in the chat. I see Ahmad has already asked a question, so please, Ahmad, by all means, unmute yourself and ask away.
Okay, let me see. Can you hear me?
Yeah.
Yeah, okay, perfect. Thank you to everybody. I know Renford's not here, but Mary and Nikki, thank you so much. I just want to, my name's Emma Talisman. I am a senior analyst with the Office of the Correctional Investigator. Last year, we did an investigation I co-led investigation into lifers in custody, looking at case management specifically. So Nikki, if you haven't had a chance to look at that, you'll see that a lot of the findings that you were talking about were mirrored in terms of the actual. Yeah, have you? Okay, perfect. So in terms of custodial process, not necessarily before and after. Mary, just a comment when you were talking about, and I was laughing and clapping the whole time you were speaking, by the way. But when you're speaking about the appropriateness of certain conditions that were imposed, one of the things, like this year, I'm co-leading an investigation looking at the continuity of mental health care from prison into reintegration, from federal prisons to reintegration. And one of the things that we're hearing a lot from, especially from CSC staff in the community, is about the appropriateness of special conditions regarding mental health. So we're hearing a lot about parole board imposing certain conditions that require, I don't know, like there's a number of different things, require counseling or require going to a psychologist or whatever it is, but without having any really due regard to what the real needs of that individual are. And then the person ends up in the community and they end up going to their case management team or the community mental health staff, and they do an assessment, and the community psychologist or the community mental health social worker and nurse, they do an assessment, and this person doesn't really need that, but still it's on their conditions. This is more of like a comment, but just to reinforce that it's kind of ridiculous, and so the person's frequency of contact remains the same, and anyways, it's just it's very frustrating.
Yeah, appreciate that information, and I think it's incumbent then on the parole officer to get the person back in front of the parole board. You know, if the condition is not working or it's no longer needed or what have you, really get back in front of the parole board and get it changed or dropped. I just want to mention, well, I've got the microphone, that in addition to the conditions, there's a whole untapped area of the instructions that are given by parole officers. I don't know if you know about this. They're authorized by statute for the, parole officer gives instructions to make the conditions happen. But boy, it's the Wild West of sentence management. I've seen some special instructions from POs. Nobody pays attention to them. Nobody reviews them. Nobody tracks them. And boy, I've heard some real lulus, which is a technical legal term, I'd have you know. But thanks for your comment.
We have other questions. Anyone want to raise their hand? We've got about 6 minutes here, so plenty of time for 10, 15, 20 questions. Yes, Deva, please go ahead.
Hi. So I am a newer member of a citizens advisory committee with the CSC in my region, and I've been listening to a lot. I've been participating in these talks for the last 3 days, and I'm not gonna lie, they feel so high level that I have so much trouble translating it into what can I do on my level, because my role, from what I understand, is to act as the liaison between the community, the people in the prisons, and the CSC, right? Because it's like advisory, impartial observations, as well as being the liaison with the community. So I'm hearing a lot about not enough is being done. That's the general sense I'm getting from all this. Not enough is being done to support the inmates and when they come out. So to basically like dumb it down a bit for me, if possible, what on my level can I do to help? Just to help, I guess. What would it look like, action on my level, that would best respond to what you're seeing as issues in the system?
Well, I'll jump in. I mean, I would say one responsibility is to bring your concerns to the attention of the regional vice chair of the parole board or of CSC, or indeed to the people at the top, to the chairperson and the commissioner. Let them know what you're seeing, what you're hearing. If it's a view shared by everyone on the CAC, make that known, or if it's just your own view. But I think bringing the information to light is so important. As we just heard from Renford, so much that is going on, people don't know about. Renford mentioned that they're having enormous trouble getting the ID. I mean, we went through this, and John Howard had an ID project in Kingston, and then we put out stuff from the department. There's no excuse for ID still being an issue. It's so easy to solve. So I think that the things that you're seeing and the disconnects, just start by bringing them to light and persistently. Don't just write one letter or email, and also write to the minister, frankly. As someone who used to, prepare the responses, I'm sorry, the ministers don't write them themselves. It matters. Minister staff read those letters. So don't hesitate to speak out.
Perfect, thank you.
I think we'll probably have time for one more. George, I think you are next, so I will let you jump in. Please unmute yourself and go ahead.
Yeah, sure. Can you hear me all right? Good. So just a couple of quick comments. Mary, nice to see you and nice to hear you. And I just wanted to pick up on your point about training for pro board members. As you may know, because we're of a similar age, Newfoundland had magistrates many years ago, many without legal training. So they did an initiative to actually have people become, in fact, get law degrees. Not suggesting that pro board members necessarily need law degrees, but I just want to support the point you made about, because there is a lot of litigation involved in pro board decisions work these days. I think that's a very, relevant comment that you made. So certainly, I support that. Also, Nikki, and your point about the young people sentenced to life sentences, I can attest to that because I coordinated a group in William Head, a 7-step group for a number of years. And it was a very homogenous group in the sense that most of our members were young men who came in at as young as 16 years old, had spent anywhere from 10 to 20 years in incarceration, and eventually did make it to minimum security because that's what William Head is. But in fact, the largest majority, I can't think of anybody that didn't come in as a young person. So that's an important fact. And I think St. Leonard's actually has an initiative now talking about younger offenders. And I think that's something that CSC does really need to pay attention to. I can speak from personal experience. I didn't get a life sentence, but I was sentenced at 16 as an adult because I'm old enough to have been under the previous laws. And going straight into a maximum security, cell block at 16 years old is not a very pleasant experience. And so, anyway, again, that's, I think, just something in terms as we look at parole and that sort of thing that needs to be considered. And sorry, just one last thing in terms of the whole process of, the reintegration. I was just at Edmonton Max last week and speaking with the warden and staff there. And we talked about the fact that most people released from a maximum security institution return. They don't really have a chance. I mean, they're coming out of a max, and what do they have? And as Renford talked about, for community supports and that kind of thing. So I really think that the whole process of being able to move people, just because they're not doing well in a max, doesn't mean they won't do well in a medium or even a minimum. And, like if some of you may know Lawrence DeSilva, and Lawrence said, well, if they'd just let me do something different instead of wanting me to fight with them all the time, then maybe I wouldn't have had to spend all that time in solitary. So, I know I'm speaking to the converted here, but anyway, just nice to hear everybody's presentation today. Thank you.
I know Catherine has finally been able to join us. Maybe Jerry's still taking the lead here.
Well, is my microphone on? Can you hear me?
Yes.
Great. I am so sorry to be late arriving. I was having technical difficulties, but thanks to Jerry's wise advice, I was eventually able to get my Microsoft Teams to work. I did hear the panels. I thought they were fabulous. I really want to thank Tom for doing such a fine job at moderating and generating questions. We now have the opportunity to go into breakout sessions to get even more opportunity for feedback and discussion. If you can stay with us, that would be great. If you have to leave us now, I do want to thank you very much for having joined us for this John Howard Society Week. I personally learned a lot. I always learn a lot from those who have experience, whether that's experience like Mary or whether that's experience like Renford's. It's always extremely insightful and really good. Tom, thank you so much. You did a great job.
Thanks, Catherine.